in breach of the covenant and has made an application to the tribunal, technically the developer can continue to develop, although there could be downsides to that as well. The most common ground of making an application is that the covenant impedes some reasonable user of land, and that's little double A. We're going to come into this in much more detail in a moment, but it can be resisted. So the beneficiaries of the land, or beneficiaries of the covenant, can resist the application made by, for example, a developer on the basis of benefits not delineated in the covenant. So as we'll see, when we're looking at practical benefits of substantial value or advantage, these aren't benefits that are actually set out in the covenant. But, says the Court of Appeal in Dobbin and Redpath and the Upper Tribunal in Thomson against Collins, no, planning didn't help. In Dobbin against Redpath, we're looking at land up in Durham, and it's to modify land as part of a building scheme. Planning permission which accorded with a development plan is not of sufficient public interest to override the objections. And in the Thomson and Collins case, land down, farmland really, down near Falmouth, the proposed development was on farmland. It was for one house and had been granted planning permission, but the only access to this proposed house was through a working farm. No practical benefits here in the Kay and Cunningham case. Now, this is the Florence Nightingale house where Mr. Kay wants to have, I think, 5 rooms as bed and breakfast. And the 2 houses nearby with the benefit of the not to use as other than as a single private residence, the coach house and something or other cottage, Lamp Cottage, I think it is, Lamp Cottage and the coach house, they don't have any restriction. They're very close to each other and there's no restrictions on how they can be used. The main building that Florence Nightingale actually lived in is slightly further away, and yet that is burdened by a restriction. So given the proximity of the benefited buildings and the fact there was no restriction between them, the tribunal says there are no practical benefits here, and goes on actually to say that as long as Mr. Kay uses a different driveway for the B&B guests to reach his house, a driveway that does not go past the 2 benefited buildings, we're going to allow that modification.